Hail to the legal warriors. In this video, I'm going to cover everything you need to know about the pluses and even minuses if you get an attorney for your protection order or restraining order hearing in Washington State. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes and protection orders all throughout Washington State for more than 25 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now, as always, I'm just going to jump right into it. What do I mean by a protection order? Well, most people in the public, they call it a restraining order. If I were to go to Google and type in, they would tell me, hey, more people call it restraining order. So we'll probably title this video something to do with restraining orders. But the law, if you're going to search it in Washington State, it's called a protection order. And that's under RCW Revised Code of Washington 7.105. And what a protection/restraining order is it's where a petitioner, that's just some human in the public, asks the court to restrain the respondent, another human in the public, from doing certain things. Don't contact me, don't come near me, maybe get out of my house, don't have contact with my children, maybe do some affirmative treatment, these type of things. And it's a civil hearing where the petitioner, the one who wants to restrain the other human, goes to court and they file a list of reasons they think the other person should be restrained under the reasons that exist under that law, RCW 7.105. The types of orders could be domestic violence. Hey, I'm a victim of domestic violence. Harassment. I'm being contacted when I don't want to be. It could be SA, something really bad happened to me. There's some others, but those are the main three that we typically see. And so when the petitioner goes in and files that petition, it's ex parte, which means there's no notice to the respondent, one side only. And so the judge will typically read the petition, and then without hearing from the respondent, they will sign a temporary protection order that will actually usually restrain the respondent. Might throw them out their house, the subjects them to arrest if they violate the order, that type of thing. And then there's going to be a hearing, typically 2 weeks after that temporary order is issued. So Lance, you haven't talked about attorneys. Well, I had to set the scene so you can understand about how a protection order hearing starts, so then we can take a look at the analysis of what are the pluses and minuses of having an attorney on either side, either for the petitioner or for the respondent. So let's start with the petitioner. So under the law in Washington State, they've tried to make it so it's easy for petitioners to request an order against a respondent. In fact, the legislature's commanded each court to make it fileable online. And so if you go to the court's website, you're going to typically see how you can fill out a petition, which is 13 or 15 pages. I'd have to go grab one, but it's a lot of pages. Fill out a petition saying why it is that you think this person has violated the law and should be subject to restraint. And it's pretty much fill in the blanks, except for the parts about talking about what the other side did. So most people will get an order from the petitioner side without an attorney. What's the advantage of having an attorney? It's going to be much stronger, right? If you have an attorney, they're going to look at the law and figure out which order to file and actually put together a really solid petition, which is going to be harder for the respondent to defeat when they file a response. And so, for example, if a petitioner comes to us and they talk to us about whether or not they should file an order, I just had someone in my office today, and while they could probably get an order, there's some good argument for not getting an order because of what it might do to reaction from the respondent. But we can help you decide as an attorney whether or not you should file the order, if so, what type of order, and most importantly, where to file your request. Because usually we have several options. A petitioner can file in a district court, which is a lower level court, or they can file in superior court, which sees a lot more protection orders, and there may be different counties you can file it in. And if you have an attorney on the petitioner side, we're going to be able to say, hey, where's the biggest advantage from what we know to give you a better chance of getting what you want? Is it district court? If so, which district court? Is it superior court? If so, which superior court? Then how can we get the result that you want? Because if you file a weak petition, you may get the temporary order, but you might be in a really bad disadvantage because you've left out all the good stuff you needed in there that you didn't know you needed, and now the respondent has a much better chance to win against you when they actually have the full hearing later. So most people go without the attorney, but you have a big advantage if you can afford to bring in an attorney as a petitioner. We usually recommend it because it's tough to do on your own. What about the respondent side? Well, if you're the respondent, that means you've been served with some type of temporary order or maybe a denial order, but you've got a court date you have to deal with. And they're not so nice when you get served. They don't give you some packet that tells you how to do it. They should. If the legislature had any fairness, which they don't in this situation, the respondent would be given, here's a nice form for you to fill out, and here's instructions how to do it. What do they give you? Zero, nothing, nada. All they do is they tell you, log into this hearing. Good luck. So if you are a respondent, of course, you have a huge advantage if you get yourself an attorney. There are disadvantages, which I'm going to talk about. There's a huge advantage if you get yourself an attorney because the attorney is going to be able to help you and hopefully for you draft a response that counters what it is the petitioner says while also protecting you from making mistakes. Because oftentimes what the petitioner alleges might be criminal activity, and we don't want respondents admitting to criminal activity in a response because all of a sudden now the police can pick that up and use it against you. It's something we have to guard against. So if you have an attorney, that attorney is going to help you decide should you even file a response, because maybe there's too much risk on the criminal side by filing a response. But if we do file a response, we're going to try to tailor it to give you the best chance. The defense attorney can also possibly negotiate with the other side, maybe to try to get some type of settlement. There's something called CR2A, and hopefully my video gurus will put a link to it right here for one of our other videos. Let me know if they did or not. So, but we can maybe sometimes negotiate that type of agreement, which says, hey, petitioner, why don't you drop your order and we'll live by this other agreement where if we contact you again, you can re-get your order. But if we don't, everybody's happy and there's no order against us as the respondent. Lance, that sounds great. Why wouldn't I always get an attorney then as a respondent if I could afford it? Well, the legislature, being super fair again, has decided that if the respondent comes in with a private attorney, the court has the power to appoint the petitioner their own attorney depending on funds of the court. And many courts will appoint the petitioner an attorney. Well, what do I care if they appoint the petitioner attorney? Well, why you care is, let's say, and this happens all the time, you come into my office and I look at the allegations of domestic violence against you, and I look at them and they're pretty weak. There's not a lot of detail. They're pretty conclusory. Well, I know that I might have a chance to defeat that as a good respondent's attorney in this hypothetical. But I also know, depending on the court, this is why you've got to talk to an experienced attorney. Certain courts 100% of the time will appoint the petitioner an attorney. Some courts 50% of the time, it depends. But if it's a weak claim against you and they appoint the petitioner an attorney, what is that attorney who's appointed going to do for the petitioner? They're going to interview them, they're going to get the evidence together, and they're going to file new and better claims against you. And now your case just got worse because you brought in an attorney. And so if there's already really detailed claims, a lot of stuff, well, then there's really no downside of them getting appointed an attorney. In fact, it could be an upside because we might be able to negotiate with that attorney better than an unrepresented person who's nervous to talk to an attorney, against them. So it depends, but definitely if you bring in an attorney on the respondent side, there's a good chance they'll appoint the petitioner an attorney who oftentimes will strengthen the petitioner's claims against you because they actually know what they're doing. If it's a SAPO, an SA protection order, the law requires that the petitioner be appointed an attorney. It's not optional if you bring in an attorney on the respondent side. So for my practice, at least, and again, these videos are never about us in particular, but this is what we go through so you can understand the reasoning. We will take a look at the situation and have a hypothetical. Is this going to get much worse if they have an attorney on the other side? Is it not going to get worse at all? Is it somewhere in the middle? And what are the pluses and minuses? And how much anxiety does the respondent feel trying to do it on their own? Are they even capable of doing it on their own? Many times people are not capable of doing it on their own and they have zero chance. And so zero chance versus a better chance, usually we want to go for the better chance. So what have we learned about the pluses and minuses? Pluses, an attorney is going to give you a better chance. Minuses, we might give them another attorney. Also, one other thing to realize, petitioner, if you bring in your own attorney, you pay for your own attorney, you are allowed to ask for fees by the respondent to pay your attorney's fees if you win your case. Now, each court is different. Some courts will do it almost automatically. Some courts will hardly ever do it. It depends on the culture of the court. Also, just because you get awarded attorney's fees, number one, doesn't mean you're ever going to get them paid, okay? Because, you'd have to sue and collect and all that. And also, it doesn't mean you're going to get all your fees. They have to be reasonable. And so usually the court's going to, you say, hey, my fees were 10x. The court might say, I'm only going to give you 5x because, they're splitting the baby. So, but that's something to remember. Respondent, if you hire an attorney, you cannot get fees out of the petitioner because, of course, it's a very fair law, right? If the petitioner files something frivolous against you and you spend a bunch of money fighting it and the judge says, you're 100% right, this never should have been filed, there is no remedy, right? So I think we all need to start putting protection orders on legislators, then maybe we'll get some fairness in the law. For now, there's nothing fair about it. So that's my rant. That's my rave. That's how it works. Hopefully you found this useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you got one of these cases in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.